May I, my lord? My lord, item number 6, my lord. I'm seeking for adjournment, my
Number
lord.
6. What do you want?
For 3 weeks, my lord. Adjournment for 3 weeks, my lord.
You are appearing for whom?
On behalf of TT Tara, my lord. Amicus curiae, my lord.
A prayer for adjournment of the hearing of this case has been made on the ground of personal difficulty of the learned amicus curiae, with a request to post the matter again after 4 weeks. Since the prayer is not opposed, same stands allowed, list accordingly.
Much obliged.
Chief, I beg to mention item number 5. On behalf of C. Modi. Respondent number 5, on behalf of respondent 5.
You have informed the other side.
Yes.
The learned counsel for the respondent number 5 prays for adjournment in this case. Since the prayer, the learned counsel for the respondent number 5, Mr. So and so, prays for adjournment in this case. Since the prayer is not opposed by the petitioner's counsel, same stands allowed, list again after 3 weeks. Yes. Item number 1,
Your Honor, the counsels are from Guwahati. In this case, they will be appearing to VC. The counsels are from Guwahati.
What are these cases for admission? Yes, Mr. Katu, what are these matters?
My lord, the issue is text for my lord, claiming text input credit, my lord. There is a certain procedure which is to be followed. But my lord, the petitioner
So
here
rule
in
16.4,
Correct, my lord.
16.4 is under challenge.
yes, my lord.
There are petitions in the principal bench where same challenge is made.
Yes, Your Honor. Also pending before the Honorable Supreme Court as well.
Yes. So then we'll adjourn it.
Yes, Your Honor.
What do you say? Right? It is submitted at the bar that the legality and validity of section 16(4) of the GST Act 2017 is under challenge in this batch of writ petitions. However, the said issue is sub judice before the Honorable Supreme Court. In view of the above, yes, we are adjourning it because the matter is pending before Supreme.
Lordship, in the last occasion, Lordship, the respondent has given a judgment saying that this matter is squarely covered by the judgment. But Lordship, it's a different judgment completely, which was passed in the year 2021 itself. And we have filed the matter in 2022. Lordship, this matter was, section 16, subsection 4 was challenged in various high courts. One of the high court was Patna High Court, and Patna High Court has decided against us. And SSC has went to the Supreme Court, and the matter is pending in Supreme Court, Lordship. Lordship has rightly pointed out in the principal bench.
Since the matter is pending before the Honorable Supreme Court, awaiting the verdict of the Appeals Court, admission hearing of these matters, 3 cases, stand adjourned for 6 weeks.
The privilege.
Obliged, Lordship.
Lordship, here we have already filed our affidavit, Lordship. We have our file.
Who is for the petitioner?
One.
So anything is,
on last occasion also the council was.
anything survives in this case? He has been released. 12 days is gone.
Yes.
That was long time back. So
Yes.
what survives? Detention was for 12 days with effect from 25/7/2023.
Oh.
Now, today, what survives? We'll close it as infructuous. Hmm?
In fact, the interim order was there, Lordship. He was not even arrested. That was for 12 days, Lordship.
Was not implemented.
It was not implemented because interim order was there, Lordship. And then
none
12
appears for the writ petitioner. Mr. S. Tapin, Lanit Senior, Government Advocate of Arunachal Pradesh, State of Arunachal Pradesh is present on behalf of the respondents. The petitioner's counsel was absent even on the previous occasion, that is on 14/2/2024, when the matter was listed before this court. Full stop. The writ petition bracket CRL bracket close has been instituted, assailing the legality and validity of the order dated 25/7/2023, issued by the Deputy Commissioner of Papumpari district, is it? Itanagar is capital. Of
capital complex.
Capital Complex, Itanagar, ordering detention of the petitioner for a period of 12 days. First up, the operation of the order dated 25/7/2023 was suspended by an interim order passed by this court on 8/8/2023, as a result of which the petitioner was not detained. First up, from the materials on record, it is evident that the impugned order dated 25/7/2023 has lost its force. Therefore, we are of the opinion that there is no live issue surviving in this writ petition. The writ petition is accordingly closed by giving liberty to the petitioner to approach this court once again if there is a fresh cause of action. Fresh cause of action available to him in such matter, in this matter.
हाँ जाऊंगा अभी वो एक केस करके जाऊंगा यहाँ ऑनलाइन हाँ
Yes,
Your Honor, I am for the appellants. Next date may be given, Your Honor.
sorry,
Next date may be given after,
why you are seeking adjournment? This is a criminal appeal.
yes, Your Honor.
You
Even,
are a legal aid counsel,
yes, Your Honor.
and then he is in jail. The appellant is in jail,
Yes.
is it not? You don't want to argue?
Your Honor, I am not prepared, Your Honor.
Why? What about the APP? The judgment is of October 2022. The appellant is in jail, and then you don't want to argue the matter. What is
Short
this?
date may be given.
Huh?
Short date may be given.
Short date tomorrow?
Short date,
Tomorrow?
not tomorrow.
Then? Tomorrow is also short date. See, you must understand, you are representing a person who is in jail.
Yes, Your Honor.
Don't take this thing so casually. Because of these things, people are questioning the judicial system. If you accepted the responsibility of legal aid counsel, then you should have come prepared. This criminal appeal is preferred from the jail. The appellant is in jail pursuant to the judgment and order of conviction and sentence passed on
On Monday, Your Honor.
31/10/2022. Serving 20-year jail sentence. First up. However, sadly enough, when this matter was listed for hearing today, the learned legal aid counsel as well as the learned APP State of Arunachal Pradesh have both submitted that they are not ready to argue the matter, and therefore have prayed for. You are ready to
Lordship,
argue?
Lordship, this matter is handling by T at the additional PP. He is not present today.
That we don't
The
know.
brief is with him, Lordship.
So all the same, you are not ready to argue.
Lordship, brief is not with me, Lordship.
I'm not writing your name. We are not writing your name. I'm not ready to argue the matter. Under the circumstances, this court has no option but to defer the hearing of this case. This matter after 10 days before the available division bench. But don't do it. You must come prepared when these matters are listed. We come reading the brief. You should have mentioned yesterday that you are not arguing. The division bench is over in 10 minutes. All right. Yes, please.
Your Lordship, this is a brief petition for grant you a payroll to my convict father who is suffering from serious health ailment. This kidney stone. Even doctor has
Why
suggested
payroll, you could have asked for a bail. Why didn't you file an application for bail?
well, he is convicted for 20 years rigorous imprisonment.
So he could have been granted conditional bail. Is
This
it not?
can be,
Okay,
yes,
on medical grounds. bail
on
can be
medical
given.
ground.
Then
So this can be converted into bail, interim bail.
bail grounds are different. Anyway, what do you, then
Lordship-
we'll have to issue notice. You will-
Lordship, last time there was an order from this court to punish the action taken by the authorities regarding the treatment given to the accused person.
Treatment is to be provided to father or the son?
Yes, father.
So the report says that they are sending the convict to the,
But they are sending it and again bringing it back tomorrow. Yesterday they had taken to AMC Dibrugarh, but again they are brought back to Khonsa because urgently surgery is required. Surgery of his kidney stone is required. But they are just taking the convict and bringing back to Khonsa again and the same day. Because at least he need to be admitted there.
so you tell us, this report also mentions that there is a surgery required. So
Lordship, will say page 9, Lordship.
page
9.
of this,
Yes.
no, but the medical advice will determine. If the doctors ask him to be admitted, then he will be admitted.
No, they have said report because here in the report itself they had said the surgery is required. I had annexed that medical report. Board of doctors who had advised him for surgery. It's in page number 12 of my petition.
So when will you get him ready for the surgery?
Lordship, we have to take the instructions regarding exact what the medical, the department in
Well,
the
Mr. DWL counsel for the petition. I also heard Mr. Y. Ram Leonard, government and,
I read them.
huh?
I.
So Leonard, government advocate, state of Arunachal Pradesh, appearing for the respondents who has produced instructions obtained in terms of the order dated 14/3/2024, which goes to show that the father of the petitioner was in fact sent to the Assam Medical College Hospital, Dibrugarh, on at least 4 occasions over the past 1 month or so. Full stop. However, for medical treatment, full stop. However, although there is a medical advice for undergoing surgery,
Yes.
the instruction obtained by Mr. So-and-so does not specifically mention as to what action has been taken by the jail superintendent for arranging the surgery and admission of the petitioner's father in the hospital in that connection. Full stop. On the request of Mr. So-and-so, let this matter be listed again on 26th of March 2024.
Can it be 25th?
26th. 25th, nobody will come.
Or 25th, it's already.
26th.
It's 26th.
2024, so as to enable him to obtain updated written instruction indicating the concrete steps, if any, taken by the authorities for subjecting the petitioner's father to the surgery in question. First up, list the case accordingly.
Oblige.
Item number 2.
My lord, today is I filing for the reply that was filed by the state respondent 4. My lord, here now respond number is manipulating the higher authority. The respondent 4 is the executive engineers PWD Dumpurijo. These statements is made that there was no internet and electricity facility at the Dumpurijo, ground of the mineral tenders. Or without the e-tenders, he stated that without, there is no any facility of the internet and electricity bills. My lord, here is that now I obtained the NOC from the additional deputy commissioners Dumpurijo. My lord, please see the annexure, my counter epidemic.
What is the contractual work here?
My lord, here
Well, I
is
think it's a inter-village connectivity, my lord. Road is village road, connectivity, my lord.
my lord, this is as part of the central sponsor scheme that the 5 crore.
No, sorry.
No, my lord, please,
It's not a central sport scheme.
my lord, please, censor order, this is the,
Nava.
So
Nava.
your grievance is that there was no proper publication of the NIT.
yes, my lord, yes, my lord. There is no properly publications, there is no provision for the mineral tenders. It should be become e-tenders, but executive engineer has done the mineral tenders. Whereas this is central sponsor schemes, the center is a sponsor of the 90% and 10% is the shared by the state government only, my lord. This central order is very clear, my lord. Please see the central order.
So have you made this Central Vigilance Commission a party here?
No.
Chief
No.
Minister's Vigilance Center. We'll vacate the stay order today. The reason is infrastructure work cannot be stayed.
Yes.
The moment these matters are listed before this court, be very clear. We'll vacate the order. But if there is some wrongdoing, then we will see what action is to be taken.
Yes, my lord.
But staying the work is not an answer to the problem.
My lord, this is a ground of the vacancy is like that filed by the learned additional session, additional government advocate. He said that there is no any internet facility at the Dumpurijo. Just mislead the court.
That's correct.
Second point is that
Please.
the publication of the newspapers. Whereas, my lord, I obtained that district library official and Upper Subansiri district obtained that there is no any receipt from the newspaper from that concerned departments. There is no availability of the newspaper publications. That only for that, my lord, is that
Mr. You're Mr.
PV.
Mr. Bui, I have understood your case.
Yes, ma'am.
I'm not saying what you're saying is wrong, but suspension of the work is not an answer for that. Because You want the entire tender to be cancelled and then a fresh NITB to be floated, then you should take part in that, something like that?
Yes, yes, yes.
Who will compensate the public for that?
My lord, become e-tenders is, it should be publication. We have no any objection for the development activities. Is my prayer is that let be the conduct of e-tender, floating of the e-tenders. Only that much, my lord. I'm not against in the development activities. It's my saying that for greater interest of the all the bidders or greater interest proper work of that area, it should be proper tenders, become competitive ones. Best of the palm should be selected. Otherwise, my lord, this is pick and choose by the that authorities who's manipulated.
You may be right.
Yes,
This
sir.
pick and choose will initiate criminal proceeding and arrest these people.
Yes, my lord, according to FIR also laws. FIR also laws the before the police station at Dumpurijo, concerned PS. FIR also laws by.
Why haven't you implemented the Central Vigilance Commission? That's what I'm asking you. If it is a case of corruption, you are saying that only to extend undue favor to some individuals, this ingenious method has been devised. That is your case.
Yes.
If that has happened, this is a criminal conspiracy. You have not implicated any of the authorities to investigate on that. Do you want the judge to go and investigate?
Now, my lord.
You want the High Court judge to go and investigate?
Yes, my lord.
Yes.
My lord, regarding of that part, that deal to the only for floating of tender, there is no work is abated. There is no any misappropriation of financial matter till now. That my plea is that let be the properly as per the direction of the state governments, as per the higher authorities of the departments, floating of tenders. Only is my plan is only for floating tenders properly. Otherwise, no any against of the development activities. It's no if the such honorable court may allow for the mineral tender for this department, the other department also similarly proceedings, so that my lord, as per the order of that state governments office notification, it should be follow up proper tenders, my lord, e-tenders.
You inflict the CVC and the Chief Minister's anti-corruption cell as parties in this proceeding. We will initiate an inquiry. And if we find that it was done in a designed manner, action will be taken against the persons responsible. That will make it clear. But there will be no stay of the work. You can argue for another half an hour if you want. I'm vacating the order of stay. You can argue. The reason is, these court orders are stalling the development projects rampantly. Even in places like Arunachal, this is creating a havoc. So it cannot be done. You have to test it. And now there is a amendment of section 41HA in the Specific Relief Act, where the statute debars the court from passing any interim order, suspending the infrastructure law. That statute has been interpreted in what is that, NG construction or something? What is that case?
NG projects.
NG projects case also 2022. Supreme Court has also said the court should not stay. So this is the law. But this court is not saying your grievance is not genuine. This court is also not rejecting your arguments. But the result you want today, that you cannot get. Maybe on the long term, yes, you want to correct this system. That we understand. And we'll examine that. If somebody is found to be guilty, doing something in violation of the guidelines, action will be taken. They may have to even go to the jail. But stopping the work is not an answer. You followed what I'm saying?
Yes, yes, my lord.
That is because there is an element of public interest involved.
Yes, yes.
We cannot close our eyes to that. Whether he gets the contract or you get the contract, it is the public which is suffering ultimately. The rainy season is approaching fast. Yes, anything you have to say?
Yes, my lord. My lord.
But these are serious matters. In Arunachal, every case, these allegations are there.
No, my lord. This case, my lord, the basic foundation was made like this. There was no any advertisement. The moment we find the affidavit annexing the advertisement, my lord, the state changes. Now, what my friend is said, this is a central sponsored scheme, my lord. My lord, your lordship may kindly see the order it said, my lord. It says,
What you said in your advertisement, let us see.
my lord, we have said in our affidavit, my lord.
Which paragraph?
Leg मत करके रखा था ना।
Yes, Mr. Nabam, which paragraph?
My lord, paragraph, start from paragraph, my lord, 6. Then 5, my lord, 5, my lord. Yeah,
When did you file the affidavit?
page, my lord, is a page 3, my lord. Paragraph 5, start from 5, the relevant portion, my lord. My lord, it's a affidavit of opposition filed by the government, my lord. Page 3, my lord, para 5. Or lordship can start from. Has your lordship got it, my lord?
Yes, but you have written a affidavit to bring certain documents.
Yes, my
That's why
lord.
the problem. Why,
But,
why have
my lord,
you?
basically, it was instruction was sought for, my lord, the document which you have obtained,
Right. Which
the honor
paragraph?
code, my
Which
lord,
paragraph?
start from paragraph, my lord, 4, my lord. Has your lordship got it? Page 2, my lord. The tendering authority, my lord, they obtain approval from the competent authority, my lord, citing that e-tender is not possible, my lord. Then, my lord, paragraph 5, the approval from the competent authority for go offline tender, my lord. Then paragraph 6 is the requisition sent to the IPR department for publication of paper, my lord. Then paragraph 7 is the paper publication in 2 local newspaper, my lord. That is, one is Arunachal Observer, then another is Eco Arunachal, my lord.
Who is the petitioner? He is also, it is also a contractor.
Yes.
He's a contractor, my lord. He's a contractor. So based on this, my lord, the order was modified, my lord. So it was modified to subject to the outcome of the petition, my lord. The last order you also find, my lord, 11-3, my lord.
My lord, this based on this.
Wait, let me finish. Now, my lord, most important, my friend has said, my lord, it's a central sponsor scheme. If lordship see the sanction order is NABARD, we have taken the loan, my lord. Had it been a central sponsor scheme, my lord, where the question of loan, my lord. Your lordship may kindly see the sanction order, my lord.
All right, so we'll issue notice.
Yes.
That's all.
No
We'll
issue.
issue notice. All right. Heard Mr. P. Goyal and counsel appearing for petitioner, also heard Mr. Solani additional AG Assam appearing for the state. Also gone through the affidavit filed by the state respondents on 7/3/2024 as per the order of the court. Full stop.
My lord, my simple
R.H.
prayer,
Navama, additional.
my simple prayer is that for the greater of interest of the development activities of that my area, let me matter maybe once such side that's a middle tender, just immediately call for the e-tenders. Only that way is my prayers that manner.
The basic grievance of the petitioner is that the work in question was awarded to the successful bidder without floating an e-tender, as a result of which it could not participate in the bidding process. First up, in the affidavit filed by the respondents, more particularly paragraphs 4, 5, and 6, the reasons as to why e-tender could not be floated has been stated. It also appears that the tender notice was published in 2 local newspapers and was issued with the approval of the competent authority. Under the circumstances, this court is of the privacy opinion that no case for interference is made out. However, since the petitioner's counsel has alleged mala fide in the action, it will be open for the petitioner to implement the CVC, mala fide in action, and considering the fact that it is stated to be a contract under a centrally sponsored scheme, the petitioner's counsel will be at liberty to implement the Central Vigilance Commission as a party to this petition if so advised. Issue notice returnable in 4 weeks. Since the respondents are already represented by the learned additional AG AP, no formal notice is required to be sent in this case. This is the matter.
Requisite copy, my lord. He has to serve requisite
Extra
copy.
copies will be furnished.
Well, in this matter, it is probably wrongly listed for motion. It was, notice of motion was already issued. And the respondents were directed to seek instructions in the matter. Probably it has been wrongly listed for motion. We are just waiting the response from the government side.
5 is also there, my lord.
Yes. What is the matter about?
It relates to a NIT process that has been initiated through a tender dated 20th of February, annexure 26. Certain conditions have been put in the tender, which the petitioners say that these are onerous and these are practically arbitrary, having no relationship with the kind of product that are required to be supplied by the bidders. The petitioner is one of the sitting suppliers of the product, and that is how the challenge has been made.
Terms and conditions of NIT.
Terms and conditions of NIT.
You know the law.
Yes, but that's why, Miller, the observation was that they should process the tenders on merit, but final order will not be issued without the leave of the court. That is the order passed by this honorable court.
Once we are also a bidder, when we came to know there is an order passed, we went to the office and we came to know there is an order passed by this court and no final order should be issued. So we are agreed because then we came to know in the order that we are also made a party.
You are appearing
for
for
respondent. But
respond
they
number?
said we will make you as a main respondent.
No,
Performer.
number?
Number
3 and 4.
3 and 4.
I am for 4.
I am for 3.
I am similarly placed. I am for performance.
And Mr. Saiwala is also.
No, that is a different matter.
It is for item number 5.
That is a different matter.
In that matter, my lord, the other side is not there.
So if your lordship is not, let the copy be served to us, Mike. We want to see what is the repetition.
In fact, my lord, on the first day, the honorable court was of the opinion that since they have been made parties as pro forma, so no notice would be sent to them at this stage. Let the government come with the response, and thereafter, if it is felt necessary, then only the notices will be issued to them. That was the understanding, my lord. And that's why the order of 4th April was passed. But in case he wants to come and participate in the matter, I don't have any objection.
By an order passed by this court.
All right, then we'll defer it.
Yes.
Where? To which date?
On 8th of April.
8th of April. Who is assisting you for respond number 3?
Mine is one of the he is unwell. He is in hospital actually.
Achha. No, who is the assisting counsel here? Will accept notice.
Winter.
Achha, you take down Mr. S. Raptal and his senior counsel assisted by Ms. So and so has appeared for the petitioner and have invited the attention of this court to the order dated 4/3/2024. Mr. R.H. Navam, learned additional AG, AP, is present on behalf of the respond numbers 1 and 2 and prays for some time to file.
My lord, yes,
Affidavit.
my lord, 2 weeks time.
Mr. D. Das, learned senior counsel, assisted by Ms.
Winter.
BINTER.
BINTER.
BINTER. Mr. or Miss?
Mr.
Mr. Binter has appeared for respond number 3 and submits that since there are reliefs claimed against his client, notice be issued.
Well, the reliefs are not claimed.
Since his client is interested in the outcome of this writ petition, hence the respond number 3 be heard in the matter. Similar is the prayer of Mr.
K. Talukdar.
K. Talukdar and learned counsel appearing for respond number 4. full stop. It appears that by order dated 4/3/2024, notice was issued only to respondent numbers 1 and 2, as a result of which no copy of the writ petition is available with the learned counsel for the respondent numbers 3 and 4. In view of the above, issue notice returnable on 8 April 2024 to the respondent numbers 3 and 4. Since both the respondents are already represented, no formal notice is required to be sent. Copy of the writ petition be furnished to the learned counsel appearing for the respondent numbers 3 and 4 during the course of the day. Let this matter be listed again on 8/4/2024 as a fixed item. In the meantime, parties to exchange pleadings. The interim order passed earlier to continue till the next day.
That is already, well, that final no work order shall be issued without leave of the
I'm
court.
changing it.
Yes.
till the
Yes,
next
yes,
day.
yes.
Well, similar, but that another item number 13.
Oh, the 13 is a different NIT, my lord. Let
But
the
issue
item
is
be
same.
Item 5.
Item be called, let's say item be called.
Well,
Item number 4.
So Lordship may kindly peruse the last order that is 12th of March. My learned friend was supposed to.
Yes.
My lord. My lord, my lord, basically, the recruitment conducted by district hospital, my lord, under DMO 0, my lord, it was cancelled basically before in the advertisement, and there was a in
So
general
why don't you
instruction.
file a short affidavit?
My lord,
Why don't you file a short affidavit?
my
We'll
lord,
have it after 3 weeks.
my lord, my lord.
2 weeks, my lord. I was making an interim prayer also, my lord. Because the only ground
See,
only.
Mr. Pani, I've seen your case.
Man,
Only if the court feels that it is a malafide action. Only then, otherwise absolutely no scope of granting any relief. They are entitled to cancel a recruitment process and they have given some reason.
yes. I've
So
seen the reasons,
the
my
court
lord.
will not go into a, what you call,
Microscopic.
microscopic.
I've understood, but there's a
dissection.
judgment of this honorable court exactly on that point, on the ratio. That's a.
So it can't be done, as you know. But if it is a malafide, you say, if you can directly link it, that it is to accommodate so-and-so or to eliminate so-and-so, something like that.
If I can show, my lord, that the ground on which it has been cancelled is arbitrary, then also, my lord.
The ground is known, they've stated.
Yes,
it.
I've seen, and there's a
That's
direct,
not arbitrary.
there's a direct judgment of this honorable court.
It's not arbitrary.
There's a direct judgment, my lord, I can show,
Direct-
on the ratio, my lord.
What is the ratio?
No, one is it was cancelled because the 1:3 ratio was not followed.
Hmm.
Here was a case, my lord, the selection board invited all those applicants who got 60 marks and above. Now, our own high court, my lord, in a case, my lord, where a ratio was not followed, in fact, less numbers were.
Mr. Pani, let us then have a discourse of the legal parameter. What is the right of your client that you are seeking?
Absolutely, sir, absolutely.
Then
I understand,
the
I
litigation
understand.
will be closed. Either it will be closed today or it can be closed after 2 weeks, that's all. But to give you a little better view, we are asking him to file an.
Yes, yes, absolutely.
What is the right? You don't have any right to be enforced, as simple as that. As
I
simple
will,
as that.
I will,
You are very unhappy with the decision, that we agree.
yes, yes.
Yeah, but then that is not a ground to pass a writ of certiorari.
But,
Unhappiness, dissatisfaction.
I will make an endeavor to
inconvenience,
convince your
what
lordship,
can
my
be
lord.
done? It happens. Many decisions are unpleasant. It affects someone. These people have been waiting for so long.
I have understood, but I will try to convince your lordship when the matter comes up for hearing.
The executive. And there is a way to express your displeasure.
My lord, I will make an attempt, I will make an endeavor, my lord.
When you get the chance, you do it. If you are unhappy with the executive action, you do it.
I have understood, my
This is
lord.
not court intervention subject. That's what
Let them file their affidavit, my lord, make an endeavor, my lord, on the next step, my lord.
Mr. D. Bamin, counsel is present on behalf of the petitioner. Mr.
D. Tagum, my lord.
D. Tagul,
For
and standing
counsel for health department.
Health
Health.
Department
Health and Family.
submits that in terms of the order dated 12/3/2024 passed by this court, he has received instructions and therefore be granted 2 weeks time to place the same by means of a short affidavit. Prayer allowed. Mr.
For respondent number 4.
For respondent number
4.
4, Mr. Soensol and GA Asan is, GAP is present on behalf of the respondent number 4. On the request of the Learned Standing Council Health Department, when, after 2 weeks, let this matter be listed again on 10th of April. In the meantime, the affidavit on behalf of the department will be filed by serving advance copy upon the Learned Council.
My lord, I am appearing in this matter, my lord.
Yes.
In this matter, my lord, this one to eligibility criteria and the condition in the tender, they have annexed another qualification point, my lord, which we have challenged. Now they have issued a corrigendum also, my lord. We have to amend that also, my lord, impugn that corrigendum also, my lord. At page 67, your lawsuit find, my lord, qualification point has been annexed, which is under challenge, my lord. This has nothing to do with the eligibility criteria is provided. Other conditions are there, my lord. The lawsuit, see, my lord, page 49. In that,
What is the matter? Mr. Saiwala, I have to put you on notice that
Yes.
the sound quality transmission is very poor. So whatever I understand, I'll pass an order according to that. That may or may not be the petitioner's case. Because
Well,
I'm finding it very, very inconvenient. There's a lag in the internet and to go very deep into matter, applying mind is getting very inconvenient for the
yeah,
judge.
my junior will be there, my
So
lord.
you take a chance. You take a chance. I'll
Junior-
try to appreciate your case.
My
but
junior
there is no
request,
guarantee.
my
Yes.
junior,
Item number 3 and 5 are similar of the same NIT, my lord. There is a corrigendum issued by the department, my lord. We need time to file amendment, my lord. We can amend the writ petition, my lord.
Corrigendum issued in respect of the.
Same NIT, my lord. My lord.
Achha, you give him first. He doesn't know. He's not aware. Mr. Nabam, you are not aware.
I'm sorry, I'm not aware. Therefore, yesterday only, I got a communication from the department, but asking for 2 weeks time to file the Paravas comments, my lord. This is no date, nothing. There is no date, only March 24.
issued, my lord.
How do you get it? No
From
date.
perhaps the client had given, my lord. It must have been
Lord,
uploaded in the
kindly
internet.
note, madam, there is no date, my lord. Only March 20.
It has been digitally signed, my lord. What I have understood from the
Even then, it's a corrigendum, sir.
All right. So you want to bring it on record.
my lord. Final amendment, my lord. We need to amend also because this was not there when we filed the writ petition. So when
Yes, but there is no request for vacating the stay order.
No, my lord. Okay, one time, my lord, 2 weeks time.
Mr. G.N. Saiwala, learned senior counsel listed by Mr. A.K. Saiwala. Mr. G.N. Saiwala, senior counsel, bracketed devote, appearing through RVC, bracket close, assisted by Mr. A.K. Saiwala, learned counsel for the writ petitioners. Submits that during the pendency of this writ petition, the Women and Child Development Department, Government of Arunachal Pradesh, Itanagar, has issued corrigendum notice dated 10th of March. Is it 10th of March?
my lord.
10th of March 2024, amending certain relevant clauses of the NIT, and therefore the petitioners be given liberty to bring this said notification on record and also to seek amendment of the writ petition with consequential relief arising in respect thereof. Mr. R.H. Navam, learned additional AG, Arunachal Pradesh, submits that he also be granted some time to seek instruction on the corrigendum notice. First of prayer allowed. Since there is no prayer from the respondents to modify the interim order dated 13/3/2024, the said order is extended till the next date of listing. List this case again on, when was the other matter fixed?
Malad, that was fixed on 8/4, Malad.
So we put it on
8/4, Malad, yes.
On 8th of April 2024, along with item number 3. along with item number 3.
Deeply obliged.
Item number 28.
Yes.
This is a contempt petition. 28, 29, 30, 31. This is a same order, same petition. And judgment of the case was passed on 9/11/2023, and thereafter, after judgment, the copy was placed before the before the chief secretary, but it was not complied the court order.
All right.
And as per the judgment, that
Right,
they
repeat
should
on
be
what Mr.
reinstated
Patil, near
forthwith.
counsel, assisted by Miss. What is your name? Your Miss D. Riba. D. Riba, direct counsel for the petitioner, alleging willful disobedience of the directions contained in the order dated 9/11/2023, passed by this court in WPC number 391 of the 2023. This contempt case has been filed. I peruse the amendments made in the contempt petition. Having regard to the allegations made in the contempt case, this court is inclined to issue notice upon response numbers 2, 3, and 4 only at this stage. As such, issue notice returnable in 6 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with AD. The question of issuance of notice to the respondent number 1 will be considered at an appropriate stage as and when the occasion arises. This is the matter accordingly.
Item number 29.
No, 29 similar order, same order. 29, 30, 31.
29, 30, 31. Same date of order is same.
Same order.
Cycle. All right. All right.
Same order.
Same order. The style of one. Order of date, the style of.
Item number 32.
My lord, only I may be allowed to persuade my lord for 2-3 minutes.
Yes, please. Why 2-3 minutes? Even little more.
Now, my lord, the thrust of my argument will be on the basis of OM dated 02/06/1999. These particularly circular and guidelines, my lord, I have the authorities, I brought it, rendered by the division bench of our High Court, rendered by the bench of Justice Sandeep Mehta, then Chief Justice, and Dev. My lord, their law is well settled. That circular is not an enforceable right now. But if the authorities who have framed it want to deviate, must give reasons, my lord. And some weightage must be given if they want to deviate it. Unfortunately, my lord, in this case, the entire process is arbitrary because they have not given the reasons. If in the absence of reasons, it is nothing but an arbitrary actions of the state in issuing the impugn transfer order, my lord. My lord, for a moment, kindly come to this particular page, the file noting which I have brought.
Yes, please. Page number?
Just page 35, my lord.
Page
35, 35.
35.
This is RTI, my lord, I have obtained it. The file noting starts at page 36, my lord. As directed by higher authority, my lord, kindly see. As directed by higher authority, the transfer posting of following officers are proposed. So and so, so and so, so.
So
my
you
lord,
are
I-
referring to page 35.
No, 35 is the RTI application which I have got the documents, my lord. The file noting starts at page 36.
All right. Yes.
Now, my lord, kindly see. As directed by higher authority, the transfer stroke posting of following officers are proposed. So and so from Yazali to EE in vigilance training chiefs against so and so EE, so and so to Yazali division against so and so. However, as per government guidelines, transfer posting from January to March is not advisable as it may hamper implementation of projects and the division, Sri so and so has already been engaged in election duty too, which my lord opined that I should make the election commission as a party, my lord. Duty 2, which may be seen at page 35 to 37. my lord. Now submitted for appropriate decision of the higher authority. My lord, this is by the section officer. My lord. Now, my lord, kindly see the file noting of the page 37 my lord, for a moment. Now it is by the joint secretary. My lord. At the transferring at this stage may invite stay from courts as it is the month end of financial year for order, please. Now, my lord, we'll see these two particular file notings thus not support the proposal of initiation of the transfer and posting, my lord. And then, my lord, transfer posting of now here, the mischief occurred from here. This file noting, my lord, Principal Secretary, note 67. Transfer posting of EEs as proposed at note 63 is approved. Order be issued immediately. Now, my lord, see, you have not given the reasons. If the transfer posting is to be initiated on a broad public interest, then I have no case, my lord. Even I would not have approached this court, my lord. Therefore, my lord, in the absence of the reasons, it is completely an arbitrary, my lord. Now, my lord, on this proposition, my lord. Now, my lord is fully aware that Bandeep Singh judgment, my lord, if you are taking a decision, administrative action must be based on rationality with impregnated reasons. These reasons are unavailable in this impugned action, my lord. My lord, I rely this judgment, my lord, that my lord is aware, but still.
No, Mr. Tara, every day, every moment is a learning experience.
Grateful, grateful, my lord.
An order is never passed before it is actually passed.
Correct, my lord.
So you have the full liberty to convince.
Yes. Well, this Manindra Singh Gill judgment, my lord, that celebrity judgment, on the basis of this, my lord, kindly come to para 4 straight, my lord.
Yeah.
Para 4, my lord.
Yes.
There can be no gainsaying that every decision of an administrative or executive nature must be a composite and self-sustaining one. In that, it should contain all reasons which prevailed on the official taking the decision to arrive at his conclusions. It is beyond cavil that any majority authority cannot be permitted to travel beyond the stand adopted and expressed by it in the impugned action. Now, my lord, I am posing this much only. I will not read further. Now, my lord has seen this two particular page, the file noting, without giving any reason. You cannot do this. then my lord will immediately ask me, see, Mr. Tara, then what is the purpose? The chief minister has exercised its power in the name of governor under Article 166. Then sub-article 1 and 2, then it has been authenticated in terms of sub-article 3 of 166 of the Constitution of India in the name of governor. Now, if these kind of irrational decisions and the actions of the government are to be permitted, then my lord will kindly recall that Marwari versus Magicians, where 1683 one crunch, page 137, in paragraph 9, Lord Marshall is the first to propound the idea of the power of a judicial review. The Chief Justice of US, when the executives were traveling beyond their periphery of the power to be exercised. The same, my lord, that L. Chandrakumar judgment is there, my lord. Ultimately, I have not brought it, my lord. If my lord resides, I can produce it, my lord. So therefore, my lord, these kind of colorable exercises in an arbitrary manner, my lord will not permit it. Then kindly come to para 7, my lord.
Para 7 of this judgment?
This judgment, my lord. Then I have one small thing, my lord. It's the division bench of our High Court. This is important for me.
Yes, please.
My lord, the 7. The same principle was upheld more recently in Ram Kishan versus the state of UP. However, we must hasten to clarify that the government does not have a carte blanche to take any decision it chooses to. It cannot take a capricious, arbitrary, or prejudiced decision. Its decision must be informed and impregnated with reasons, my lord. So therefore, my lord, there is no reasons in the file noting. This cannot be, my lord. If at all, we are not saying that you don't have the power, you have the power. Because my lord will immediately recall that fundamental rule 11 to 50. Whole time of a government employee is at the discretion of the employer. Where to post, where not to post.
Where is the impugned order, Mr. Tara? Which page?
Impugned order is at page 27.
What, 27?
27.
Your client is at number 1.
Right, number 1.
How many days has he spent in Yazali division?
No, there is no quarrel. I have completed
No,
my.
I want to know how many days.
3 years. I'm not quarreling on that.
Yes.
What I'm respectfully saying is, you have these guidelines. Even the file noting has clearly reflected till 31st March, you don't disturb. It will invite the intricacies of the court actions. Then, my lord, kindly see bottom, my lord, date. My lord, the order was passed at 4:25 p.m. in the evening, my lord. Now, next day, the model code of conduct has to come. Now, in the same evening, my lord, I have not annexed all those documents, even all those circulars, because this I have not obtained through the RTI. And then, my lord, in the evening, my lord, Itanagar somebody is sitting, my lord. Yazali somebody, nobody was there. Zero somebody was there. And then entire thing, my lord, that tier 1 for the executive engineer. Then all those things were being done. And my lord, the election commission, which I'm grateful to my lord that day, I have made the election commission as a party because I was already assigned to the election duty. Now the guideline circular which says, if there is an administrative exigencies involving larger public interest, I need to be transferred out. At least you should have consulted the election commission. That was not there, my lord. So now the propositions that I'm putting forward. Where is the This is very unfortunate. Now, my lord, I'm saying that kindly have this 2024 1 GLT. 2024 1 GLT page 1. Now, the question is, prima facie from the file noting my lord has sent, this is nothing but arbitrary and nullify the exercise of the power, my lord. Now, the broad principle, my lord, has been discussed in paragraph 11. Well, para 11 talks about exercise of power relating to order of transfer, legal malice or legal fact in law means something done without lawful exercise. Para 11, Lord. It is so beautifully described in this judgment. It is authored by Lordship Arundev Chaudhary. The composition was then Chief Justice or Lordship Mehta was there, Sandeep Mehta. May I proceed with reading this?
Yes, which
Yeah.
paragraph?
Para 11, Milord, at page 7.
Yes, please.
Yeah. The Honorable Apex Court, while dealing with decision of transfer order of a judicial officer issued by full court of Madhya Pradesh High Court in so and so, reported in so and so, also extensively dealt with the concept of malified exercise of power relating to order of transfer. At paragraph 58, the Honorable Apex Court held that state is under obligation to act fairly, ill will or malice in fact or law. It further went to hold that legal malice or malice in law means something done without lawful excuses. Lawful excuse. It is an act done wrongfully and willfully without reasonable or probable because, and not necessarily an act done from ill feeling and spite. It was further held that when an order is not based on any factor German for passing an order for transfer, the order is based on an irrelevant ground, such an order would not be sustainable in law. The first proposition on which I'm relying. Now, paragraph 12, Lord. The transfer policies and guidelines I'm stressing on this, Lord. The transfer policies and guidelines are formulated to regulate the policy of government employer. Such policy generally includes the tenure of posting, the different conditions of transfer, etc., which are formulated on the basis of the need of the department. Therefore, such policies and guidelines are judicially declared to have not created any enforceable right upon an employee. The Honorable Apex Court in the case of Registrar General High Court of Madhya Pradesh, Supra, dealing with the transfer policy of Madhya Pradesh High Court and recognize the principle that the transfer policies and the guidelines are not having any enforceable right, relying on earlier decision of the Honorable Apex Court, held that though mere reasonable or legitimate expectation of a citizen may not by itself be a distinct of enforceable right, but failure to consider and give due weightage to it may render the decisions arbitrary. It was further held that requirement of due consideration of a legitimate expectation forms part of principle of non-arbitrariness, which is a necessary commitment of rule of law. Finally, the Honorable Apex Court held that though the transfer policy may not be enforceable in law, but when such transfer policy has been framed, every officer will have a legitimate expectation that such a policy should be given due weightage when cases of transfer of officers are being considered. My lord, with great respect, my lord, at least should have. Now, my lord, kindly come to para 24 and 25.
Para
24 and 25 of this judgment. Beautifully described, my lord. The answer is given. Now, how the finding was, the same thing. We are constrained to hold that the transfer order so far relating to the appellant is concerned, the same was done without any lawful reason, in as much as no exigencies of service and public interest which lead to such transfer is discernible from the record, except so and so, so and so. Now, therefore, this court is of the unhesitant view that the impugned transfer is actuated by malified exercises of power and issued without being any public interest or exigencies of services. Now, final paragraph. 25, I'm reading. Yet another aspect of the matter is that transfer policy, as discussed here and above, was formulated to regulate the transfer of government employee in Education Department of State of Arunachal Pradesh, which covers all administrative cadres, including principal and director, etc. Such policy is included the tenure of posting as 5 years and also include different conditions, considerations of transferring, including hard posting, etc. In the case of Registrar General, High Court of Madhya Pradesh Supra, it was held that though such policy and guidelines do not create any enforceable right, however, the employee shall have legitimate expectation for proper implementation of such policies, and that though such legitimate expectation is not by itself is a distinct and enforceable right, however, failure to consider and to give due weightage to it may render the decision to be arbitrary. In considered opinion of this court, in the given facts of the present case, the above decision squarely covers the controversy at hand in as much as the appellant was transferred and posted after giving due weightage to his request, including his date of so and so, while transferring back as reflected in the record. No considerations under the transfer policy was made, nor any exigencies of service are discernible from such exercise of power, and therefore such exercise of power is nothing but an arbitrary exercise of the power. The Honorable Apex Court, my Lord will mark this, the Honorable Apex Court in the case of Poonam Verma versus Delhi Development Authority reported in so and so also had expressed the view that the transfer guidelines are advisory in nature. However, same can judicially reviewed when deviation of such transfer policy involves arbitrariness. The para 26 also comes in my favor.
All right, so, yes.
My Lord, please, till 31st. I'm saying, not saying nothing much, my Lord. Kindly come to their guidelines, which they have framed for a moment, my Lord. I am not
Mr.
praying.
Kara, please conclude now.
I'm concluding, my Lord.
I've heard you for half an hour, more than half an hour. Transfer matter.
My Lord, only reading that. Well, only this guidelines, kindly up guidelines. Guidelines, my Lord, has seen 026/1992, 1F, my Lord. Till 31st of March, you cannot transfer. That is the bone of contention, my Lord.
Page number?
Page number, my Lord, just page 40, my Lord.
Page 42.
Page 40, 40. My Lord, type copy is at page 43, my Lord.
Yes.
2nd June 1998 guidelines, my Lord. Now, my brother Tapin and others, they will come and say that you are from this particular district, this, and then the election commission, this guideline, these were all misconstrued. Whereas the file noting says it was not based on the guidelines of the election commission, my Lord. Kindly see, my Lord, no transfer should take place in the last 3 months of financial year. That is what is the reflection in the file itself. Grateful, my Lord.
Yes.
May I please? Lordship, kindly come to page 43, Lordship. Page 43, Lordship. This is a guideline.
23.
Page 43, Lordship. 43, Lordship. 14, which my friend has referred just now.
Yes.
This is a type copy, Lordship. The original is at page 40, Lordship. Kindly come to the serial number 1 of the guidelines, Lordship. No officer of group A and B should be posted in his home district so that he does not develop vested interest, Lordship. The petitioner is from that particular constituency, Lordship. Very constituency, Yajali constituency, Lordship. And all posting, including those executed in the office of the head of the departments and in districts, should be normally for a period of 3 years. It has been amended now, Lordship. The normal period, Lordship, is two years, Lordship. As per the guidelines, Lordship. Now, Lordship, the petitioner has already spent 3 years and 9 months in this particular division, Lordship. Earlier, it was 3 years, Lordship, normal period, Lordship. Now it has been amended and now it has been brought down to 2 years, Lordship. Petitioner has spent 3 years and 9 months in very division, Lordship. petitioner is from that very lordship district and constituency, and he is dear lordship in violations of these very two lordship instruction lordship. Now lordship. Then lordship, this is the lordship how lordship the guidelines is being followed lordship. Then kindly come see this instruction by the Election Commission of India lordship. Kindly come to this is issued by the Election Commission of India lordship. The serial number 2 lordship. Serial number 2 lordship.
Yes.
The commission has been following a consistent policy that officials directly connected with conduct of elections in an election going state /UT are not posted in their home district or places where they have served for considerably long period lordship. This is specific directions issued by the lordship Election Commission of India lordship. This petitioner, as I have submitted lordship, 3 years and 4 months, and he is from very district lordship and very constituency lordship. Then the instruction number 3 lordship. Here also lordship has to be done. This is lordship the instruction issued by the. Now lordship, after lordship this order has been issued. Order has been issued lordship. The private respondent has already taken over the charge lordship. And he has been substituted in place of the petitioner in the election duty lordship. This is the lordship the past one lordship, the order lordship. This the petitioner was given the election duty for this particular 5 polling station lordship. Now it has been substituted lordship. The present incumbent, there's a private respondent has been given that lordship, duty lordship. Now he's taken over everything lordship is completed lordship. Now, if may I take lordship to the representations to the petitioner lordship. The representation lordship. And the entire pleadings in the read petition also. Page 28 lordship. Principal Secretary so and so lordship. The Para 1 lordship. That it is to state that by transfer posting order so and so being memo number so and so issued by the Principal Secretary, if it's government operational parties, whereby I have been transferred from Yajali Division to Office of the Chief Engineer so and so by Takum Nalo after appoint me as a sector officer at A sector all 0 Lower Sulawesi district for simultaneous Lok Sabha and Assembly elections so and so. That my transfer order dated is in violations of the transfer posting so and so, which provided the transfer oblique posting orders shall be issued by April, that is immediately after financial year ends, and no transfer should be take place in the last 3 months of financial. That also in my case, no public interest is involved, which discernible from the transfer order itself, that only me and Takum Nalo have been transferred in violations of the guidelines regulating the transfer and posting of the public servant, which notified so and so. It is for the reasons that there have been a larger public interest involved, then it could have been in form of mass transfer and posting. Therefore, I request your copy so and so, please revoke so and so and so. Here also just what I'm trying to point out, here as a matter of principle lawsuit. Simply the violations of the right is not sufficient lawsuit. One must sustain some lawsuit, legal injury lawsuit. If lawsuit see how this transfer posting order has affecting the petitioner lawsuit, here only simply his lawsuit, agitating lawsuit, it has been issued in violations of the lawsuit for guidelines only lawsuit. And he's there in violation of the guidelines itself lawsuit. When himself he is in their lawsuit, in violations of the guidelines laws, can he take that benefit lawsuit? No reason has been recorded lawsuit. One submission lawsuit, to that extent that when it's in deviation from the guidelines or set norms, if any action is taken, to that extent, I agree lawsuit, the region, and at least minimum region has to be their lawsuit when it's in deviations of the set norms lawsuit. But here, the petitioner himself is in violations of their law. Can
All right, you have argued that. Anything else?
Lordship. Then Lordship, petitioner is Lordship asking for 10 days Lordship. Today is 31st Lordship. Here Lordship, vesting and divesting and again vesting, it will interfere the election process Lordship. If any interim order is passed or it's allowed Lordship. Because now Lordship, already the duty has been vested to the private respondent Lordship. If any interim order or any order is passed, then it will divest.
Who is appearing with the private respondent? Your client has joined.
Yes, my lord, I have already taken the SAT also. Now I am on duty as a sector magistrate. I appointed by the district election officer, deputy commissioners. I have already, my lord, my duty shirt. I was doing duty.
And who's for the Election Commission of India? What do you have to say?
We have already issued one order on that. I will bring my special signature also. The special signature of the bank.
And here Lordship, the 10 days in the public interest.
My lord, one thing, the senior government advocate argument is not sustainable at all. See, I have already taken, my lord, to the file noting. File noting was not on the basis of this particular election commission guideline. Therefore, all his contentions.
Have you alleged any malafide in this?
Yes, yes, my lord.
Where is, which place, which para?
Kindly, my lord, no reasons. Paragraph 17, I have at page 14, page 19, I have violated, alleged the norm, then 20 arbitration, arbitrary, 21, no pause and presence. My lord, may dispose of this matter instead of keeping pending.
No, where is the allegation of malafide?
But there is one particular paragraph. Paragraph 26. 26. That the petitioner humbly submits that the actions impugned in the instant case are expressly illegal, arbitrary, irrational, unfair, unreasonable, capricious, and illegal. The said impugned action is fraught with arbitrariness and malafide on the face of record. No person reasonably instructed in law could have resorted to such action as has been taken by the respondent authority, and the said is perverse in law.
No, you are alleging malafide. These are all general submissions.
Yes.
Malafide against whom?
That
all of them can't be guilty of malafide. You have to
accommodation is at para 22, Milord. To accommodate the private respondent.
No, who is trying to accommodate the private respondent?
By these illegal actions.
Malafide without including the party laws.
These are very vague allegations. The court cannot give a finding on that. Every petition, last two paragraphs are illegal, arbitrary, capricious, malafide, these, that. This is a general kind of a pleading. But is there any specific plea of malafide against any of the officers?
While drafting, to be very fair, while drafting, this note was not obtained through RTI. So normally, when I sit on giving dictation to my younger, I used to ask the client first, where is that file noting?
No, correct.
From file noting, and it was.
That's all right.
But that's why, that general noting is.
This is not a comment against you or your chamber junior.
Correct.
We are only asking about the petition.
That's why, that particular.
Do you want to add any pleading in this? Is there any pleading you want to bring in?
We can.
No, it's up to you. I can pass an order on this, whatever is there. But if you want to bring any pleading, then it is your choice.
Well, till 31st, I may kindly be protected. Till 31st.
So that is your submission. The
Yes.
court will consider and pass an order. It may be granted, it may be rejected. But before that, what do you want to do? Any further pleading or right now? Nothing?
No further pleading. And then, required with this may be disposed of so that this writ petition can be disposed of on merit. My lord will pass any appropriate order.
Mr. Tara, please I'll go through the record and pass an order.
Correct.
I appreciate your efforts,
Correct.
but keep in mind two things.
Correct.
Take it as an advice.
Yes, yes, madam.
First of all, legitimate expectation is a protection against arbitrariness under Article 14. The division benches also held that it is not an enforceable right. Certainly it is not. It is just a matter of protection. That in a, say for example, in a particular office, there are 10 people similarly situated. If you regularize 8 and leave out 2 without any reason, then they will come in. Legitimate expectation is a facet of Article 14. In transfer matters, these things don't come into.
My lord is on that Govardhan Lal judgment.
Yes.
I understand.
The transfer matter doesn't come in because imagine a situation where you are the CEO of a organization.
Correct.
You must have the liberty to place your people wherever you want. Only thing is, if it is done in with a malafide intent to harass someone, to put a punitive sticker on that person, and that person is helpless, nowhere to go. It is in those circumstances the courts come in rescue. But somebody who has spent 3 years, 9 months wants to only stay till 31st March. How is the court bothered? 31st March or 41st March? How are we bothered? We want to sign checks, and that is the.
No, my lord, that is not intention. My lord, only, my lord,
What is the case made out here?
my lord, only there is a small thing. Kindly, well, policy decision we cannot examine, but process of decision-making process. The decision-making process.
To be assigned in a transfer order. That's the law. If they are to pass reasons, issue notice, show cause why you should not be transferred, then is this how transfers are to be done?
My lord, kindly have my lord, dictating judgment, kindly have a look on the ratio laid down in Silpi Bose judgment.
Which case?
Silpi Bose. I can.
What Silpi Bose?
Yes.
I know.
Yes.
What is that you want to?
The principle is that
What is the
if
principle?
you are going to act, issue transfer and posting orders, if it is done perverse to the petitioner or any employee, then these are check and nuts in view of this judgment.
No, what is the 31st March? You are not allowed to be there. How does it matter? 31st
It
March.
matters, my lord. There is a WT
What is
message
your
also.
interest to stay there for 31st March?
Sorry, my lord, I cannot argue. My lord.
So then,
With great respect, my lord.
I think you should withdraw this petition.
My lord will proceed because what happens? We as a court officer, my lord, we have to come and try to persuade their lordships. And their lordships.
I appreciate your
Yes.
effort, Mr. Thakur. You have to do your job as a counsel. But this is a very, very bizarre stand of your client that I want to be there till 31st. Only for 10 more days I want to be there. And in the attending circumstances, elections notified, the reliever has joined, he has been assigned election duties.
My lord, kindly.
You spend more than 3 years, 9 months in that place.
My lord, kindly also bear in mind at 4:25 p.m. the order was issued, and the relieving order was also issued at that night. And then, my lord, that
They
kindly.
wanted you out of that place by hook or by crook. They wanted you out because it is your home constituency. What is wrong about it?
But my lord,
You can't be there.
My lord,
You can't be. See, the reason is putting you back in Yazali will be in violation of the model code of conduct of the election notification. That means you will be assigned election duty in your home constituency, which cannot be done. That's what I am saying. If you want, we can give you a little time. I'm trying to be fair, both sides. Think about it, whether you want to pursue this and invite an order.
my lord, kindly give me a day's time. It may be listed day after. I'll bring one. I will file one additional affidavit. But that cannot improve my position. That cannot improve my position. But that Malafaidi thing I can explain in that. Whatever, my lord, as a court officer, I have done my duty.
No,
My lord
that's
will
all right.
decide and
That's
then
all right, Mr.
kindly
Thakur.
pass. Grateful, my lord. Grateful.
We will have to go by the.
Correct, my lord. Yes.
It is not that in one case you take a view on another case.
Correct.
But yes, I appreciate your efforts. You have put in a lot of hard work. I can see that. but I can write a 15-page judgment just now. If you want, I don't think it will be a good idea for your client. The decision you relied upon in Bandip Singh, that is on a tender matter.
Correct, but the principle of law we can
Tender
improve.
completely different.
Administrative,
Completely different principle.
correct, correct. My lord.
Service transfer is an incident of service. You are bound to go anywhere.
That,
In 7 days, if they have reasons to transfer in 7 places, you are bound to go.
S.R. Subramanian
But
judgment
these
is
are
very clear.
cases, if it is a completely unusual move and the person complains that I have been subjected to harassment, the courts will look into it because it is a question of a citizen's right. You spend 3 years, 9 months in your home district, you want to continue there for 31st March and you want a court order to do it.
Well,
It will
that
be
SL,
completely questionable order.
well, I have seen using SL hours
But
judgment also.
on the request of Mr. T.K. Tara, learned counsel, appearing on behalf of the petitioner, this matter we posted again next week on 26th. On
Okay.
26th March 2023, so as to enable him to file an additional affidavit amplifying the plea of mala fide
Correct.
brought against the authorities in assailing the impugn order.
Much obliged.
All right. Beyond that, this much is only for Mr. Tara.
Yeah, that
Otherwise,
SL
I was
hours,
thinking of dictating
no,
the
no,
judgment.
that SL hours judgment is also very clear.
Which one?
SL hours 2010-13 SSC.
It's clear on what?
That transfer and posting is an incidence of service. I am aware of that.
You have tried.
That's why I have.
You have
followed
tried.
that.
Someday your arguments will be reflected somewhere,
Correct.
but it will. You may be there in a respondents, the respondents council.
No, my lord, that's why my lord has given me a lot of indulgence. That's why I tried to refer this Madison versus Marbury and that L. Chandra Kumar, 1997, my lord, 4 SSC, page 4 to 2 to 48.
Chandra Kumar, what?
Yes.
Para 93.
Yes, yes, my lord.
All right.
Number 33.
May please, your lordship. My lord, here I am seeking for constitution of a DPC to consider my case for promotion. Last 3 years, my lord, DPC has not been held. OM, my lord, provides for sitting of DPC every 6 months, my lord. I'm praying for notice at this point.
Will issue notice.
Yes, my lord. My lord, I'll be appearing for 1 and 2 only. There is a standing counsel, Mr. Parme, L. Parme. He'll be receiving on behalf of 3 to 5.
And Mr. D. Pangil, and counsel appearing for the writ petitioner. Peruse the averments made in the writ petition. Issue notice of motion returnable in 6 weeks. Mr. N. Ratnam, an additional AG, State of AP, has appeared and accepted notice on behalf of respondent numbers 1 and 2, whereas Mr. L. Parme, learned standing counsel, Power Department, State of AP, has accepted notice on behalf of respondent numbers
3, 4, and 5.
Respondent numbers 3 and 4.
Oh, 3 and 4, sorry.
What about 5? Mr.
5
S.
from government.
Huh?
5
Additional AG, you must accept notice for 5 also.
5, yes.
So 1, 2, and 5, and 3 and 4, Mr. L. Parme. In view of the above, service of notice is deemed to be complete in this case. Extra copies of the writ petition were furnished to the learned department counsel, requisite in numbers, so as to enable them to obtain instruction and file affidavit. Register to list this case again by reflecting the name of learned counsel for the respondents in the court list.
Item number 34.
My lords, I am appearing on behalf of the petitioner in item number 34 and 37.
36, I think. Same case.
Who is appearing?
My lords, I am appearing. my lords, I am appearing for the petitioner in 34 to 37.
Yes, what is your case? You are appearing for whom?
I'm appearing on behalf of the petitioner, but the matter speaks through RC. So I'm here just to submit the synopsis of the case. Just to submit the synopsis of the case, sir.
You are appearing for petitioner.
Yes.
Who is for the respondent?
Respondent.
Who is the counsel for the respondent? Where is Mr. M. Kato? He has not come to court today. Okay, after some time, you call Mr. Kato. Then we'll take up. After some time. All the other matters.
Number 6.
Yes.
May I please, Lordship?
Yes.
Lordship, I am appearing on behalf of A. Bhattacharjee, Learned Counsel. Your Lordship, the Learned Counsel is not in his station, he's out of station. Your Lordship, seeking adjournment, matter may be fixed after 4 weeks.
After 4 weeks, Your Lordship.
The petitioner's counsel seeks adjournment in this case for 4 weeks on the ground that the arguing counsel is out of station. The prayer is not objected to by learned GAP. In view of the above, the prayer stands allowed. List the matter again after 4 weeks. Yes.
Obliged.
Item number 7.
After 13, then you call matters. Up to 13, you call serially. Then
May I please, boss?
after 7, 8, 9, 10, 11, 12, 13, then 10, 12. Yes. Yes.
May I please? My lord, I'm challenging this petition regarding cancellation of entire selection process, my lord. Without there being any, my lord, justifiable ground, my lord. My lord, this impugned cancellation order is at page 35.
Impugned order is page
35, my lord. This is notification dated 30th September 2022, madam. This is for general information that the recruitment test, written examination, and speed test of stenography for the post of senior personal assistant stand cancelled due to administrative reason in terms of advertisement dated such and such dated 11 March 2022.
So respondent numbers 1 and 2 have filed affidavit.
Yes, ma'am.
You don't want to file rejoinder.
My lord, since my lord, there is
No, it's up to you.
Yes, ma'am.
But if you don't file rejoinder, we'll go by what they say. That's the law. Then we'll dismiss your petition. They have given the reasons why it has been cancelled.
But my lord,
you take 5 minutes, 10 minutes, 15 minutes, we have to dismiss. They've given the reasons. See the statements in paragraph 4 onwards.
Yes, ma'am.
If you don't dispute it, then there is some reason to cancel. That's all. They can cancel it. Only thing is that should not be done arbitrarily. They have given the reasons. You are not contesting it.
That is with regard to the paper leakage, with regard to other examination, not regarding this
But
examination.
you are not disputing it. Then you have to file rejoinder.
In that case, man, I take some time to file reply.
Yes, you see, we have to go by the correct legal procedure.
Yes, ma'am.
If you don't contest their statement, then we have to accept it as correct. You can't say that I'll not file rejoinder, but it's not correct. That you cannot say. You want to file or not is up to you. If you don't want to file, we'll hear it today itself. You want to file or not?
I will file.
They've given the reason. They've stated why they have cancelled it.
Yes, ma'am.
How is the court supposed to ignore that? If you can contest it and put other materials, then only we'll ask them why have you made this statement. Let them file rejoinder. Mr. H. Lampul on a counsel for the writ petitioners prays for and is granted 3 weeks time to file a rejoinder in response to the counter affidavit filed by the respondent numbers 1 and 2. Mr. A. Upon Lana senior counsel assisted by Ms.
N.
So and so is present on behalf of the respondent numbers 1 and 2.
All right.
Item number 8.
But this is pertaining to non-payment of the admitted amount. You may kindly come to see the order.
My lord, before sorry, my lord, in this case, it was earlier handled by my colleagues, madam. I've been entrusted with this case, my lord. I'm appearing for the first time, my lord. So I need to take instruction from the competent authority, my lord, regarding this, my lord. And my name also not reflected in cause, but I'm appearing the first time, my lord. Earlier, it was handled by the earlier council, my lord, the Jamo. And now I'll be handling, my lord.
The payment of contractual dues.
Yes, my lord.
So that is admitted, madam, in 18.8 observation, your lordship already prima facie is already made an opinion also.
I need to discuss with the authority, my lord, because the brief also, it was only morning only I got, my lord, this file. That's why, my lord.
You will give him one last chance.
My lord.
All right, heard Mr. T. Parton, and counsel for the petitioner. Mr.
P. Tagum,
P. Tagum, learned counsel,
Standing Counsel for Education Department.
Standing Counsel Education Department, AP, has appeared on behalf of the respondent numbers
1, 2, 3, my lord.
1, 2, and 3, and submits that after a change of counsel, he has been entrusted with this brief only this morning,
My lord.
and therefore 3 weeks time
My
to
lord.
obtain instruction and file affidavit. Considering the relief prayed for in this writ petition, this court is inclined to grant 3 weeks time to the learned standing counsel for filing affidavit by making clear that no further adjournment will be granted to him on the same ground. Let this matter be listed again after 4 weeks.
Deeply obliged, madam.
Item number 9.
Yes. Your Honor, this is a petition seeking appointment of arbitrator, sole arbitrator. On the last date of hearing.
Where is the arbitration agreement?
Yes, Your Honor. Your Honor, may come to page number 120, Your Honor.
Sorry?
Page number 120, Your Honor.
121.
120, 120, Your Honor. Your Honor, it's clause number 13.1, Your Honor. Resolution of disputes and arbitrations thereof. Your Honor, if I permit, I can read. May I read this clause?
You see, these matters are to be disposed of and dealt with very expeditiously.
Yes, Your Honor. Yes, Your
But there is a problem here. You have to address it. Unless they go for a waiver, it will be difficult. There is a decision of the Constitution Bench of the Supreme Court
Yes,
that the arbitration agreement must specify that the arbitral award will be final and will be binding on both the parties.
Yes, Your Honor.
Without that, there is no arbitration agreement.
Yes, Your Honor.
So this clause does not mention that.
Your Honor, but the Supreme Court judgment also say that if there's an arbitration clause way, there has to be just arbitration agreement, Your Honor. Whatever contentions a party has to make, they can make before the arbitrator under section 16. Even if it is a dispute pertaining to whether it's written or not, Your Honor, that can be raised before arbitrator. But the judgment do say that the arbitrator should be appointed and the matter should be go to the arbitrator for adjudication. Your Honor, in section 11, Supreme Court judgment say there is a limited intervention of the court at the stage of reference, Your Honor. At the stage of reference, the court only has to decide whether there's an agreement for arbitration is not.
We'll observe it, but the arbitration will fail because the Supreme Court judgment has to be complied with.
You know, I have
Unless the arbitral clause says they are, arbitration clause is binding and is final in nature, binding on both parties. The Supreme Court says it will not be treated as an arbitration agreement.
You know, then I seek some time to reply to that contention, Your Honor. I'll file the judgments also, Your Honor, to that extent.
You are an outstation counsel. You are coming from outstation.
Yes, Your Honor.
What do you have to say? We'll appoint an arbitrator and leave the question of jurisdiction open.
Lordship, so for appointment, as Lordship has referred one.
No, but that is not your contention. The court has pointed out.
Otherwise, we are not objecting, Lordship. And here we are proposing Lordship,
whom?
Justice BP Katagi's name, Lordship. We have taken consent from him also.
Right. Where is the list? Where is the list?
Your Honor, this is the list.
And where is the letter demanding appointment of arbitrator?
Yes, sir. The notice of invocation is on page 208, Your Honor.
Page?
208. And it's a P13, Your Honor. P20. It's the notice of invocation dated 10th of July, 2021.
So Justice BP Kataki, both of you are agreeable?
No, Your Honor, I just request the arbitration claim pertains to over 200 crore rupees, Your Honor. So I request a retired Honorable Supreme Court judge might be made the arbitrator, Your Honor.
Acha, where is the page number?
Your Honor,
The demand is there, page?
Page number 208, Annexure P28 is the notice of invocation, Your Honor.
No, where is the request for appointment of arbitrator? Where is it?
Your Honor, this notice.
Please point out that line where you have asked for appointment of arbitrator.
Yes, sure. Your Honor, page number 227, para 63.
Yes, what do you have to say to these four names in page 227? Number two, serial number 2, are you agreeable, both of you?
Yes, Your Honor.
Justice Madan B. Lakur, he was a former judge here. I'm picking this name because he will have an understanding of Arunachal.
Yes,
Lordship, our reply is at page 230, Lordship.
Yes, what is, you have contested this?
Here we have proposed, if Lordship say the page 242, Lordship. Wait, remember. We are proposing for Lordship three lawsuits.
Is acceptable to you, you say.
Yeah, this he's acceptable to us lawsuits. And then we are
So
proposing.
that will not go to the rest of the things.
lawsuit.
If it is acceptable to you among the four names they have suggested, you say Justice Madan B. Lokur is acceptable to you. So we'll appoint him as the sole arbitrator.
Sole arbitrator.
You take down. Heard Mr.
Anant Kanojia.
Anand?
Anant
Please
Kanojia.
give it in writing.
Yes.
Learned counsel appearing for the petitioner also heard Mr. S. Tapin, learned standing counsel, learned government advocate Assam, state of Arunachal Pradesh, appearing for the sole respondent. Full stop. This petition, no, you're right. This application has been filed under section 11 bracket 6 bracket close and 5 bracket 5 and bracket close 6 of the Arbitration and Conciliation Act 1996, seeking an order for appointment of an arbitrator to enter into a dispute raised in this petition. Master. It appears that the
Lawsuit, I guess. Here, lawsuit, we are proposing for three members arbitration. Here, so far, Madan B. Lokur is concerned. We are acceptable to that lawsuit. Apart from that, we are proposing one from us lawsuit. We have given the name.
It's the arbitration clause is silent with respect to the number of arbitrators. In the event, in such an event, Article Section 10(2) of the Arbitration Act shall apply.
Let us see where is arbitration. Section
10(2). Number of arbitrators. The 10(2) states that failing the determination referred to in subsection 1, the arbitrator shall consist of a sole arbitrator.
So you are not agreeable to a 3-member arbitral tribunal?
Your Honor, we are not agreeable. We are not agreeable because it's be very expensive, Your Honor. It would not be cost effective and very expensive, Your Honor.
Oh, expensive or not? That's
And Your Honor, like and the arbitration clause, Your Honor, silent.
Arbitration on a 200 crore claim and
Yes,
you
sir.
want it to be cheap.
Substantial amount, Your Honor, has been invested in the project. Your Honor, that's why we are agreeing to sole
And
arbitration.
then this aspect of the matter has to be adjudicated first.
You know, I can produce a judgment also to that effect. If there's a dispute, there has to be a sole arbitrator, Your Honor. You know, para 55 of the last page.
Para
55, the last page. Last. In view of the instance of the breaches of the terms and conditions of the relevant clause of the agreement, coupled with the breaches of the specific obligation and responsibility contained in the appendices and enclosure attached and incorporated by the reference as an integral part of the agreement, and having regard to the words used in clause 10 of the agreement, and having regard to the fact that the parties have failed to determine an even number of arbitrators as per the provision of section 10(1) of the Act, the requirement of section 2 of the Act is fully attracted in the present proceedings. In other words, the arbitration agreement deemed to be one providing for a sole arbitrator.
So where is the MOU? MOU was signed by your client with the state.
Yes, sir.
What is the date of the MOU?
20th of May 2009.
20th of
May 2009.
And that the MOU is a part of the record?
Yes, sir.
Which page?
Page number 107.
1?
107. to 125, Your Honor, is the MOU.
And this clause 13.1 is a part of this MOU.
Yes, Your Honor.
This MOU was signed for construction of a power project.
Yes, Your Honor. Hydroelectric power plant, Your Honor.
Hydroelectric, what is the name of the power project?
It's for Tawang Valley, Your Honor.
Sorry?
Tawang Valley.
I'm not understanding anything. What are you
District
saying?
Tawang.
Huh?
District Tawang.
District Tawang.
Tawang.
That is the name of the project.
You know, the project name is Hydroelectric Power Plant only. It's called Nyamjang Chu. Your Honor.
I have to now think, I'll now have to think of the next date. You are not
No, Your Honor.
What is the name of the project? How many projects are supposed to be established?
You know, one project, it's
One project.
Nyamjang Chu, you know. Nyamjang Chu Power Project.
Nyamjang Chu Power Project.
Yes.
Then what happened? You have made investments, but after that,
You know, we received environment EC in 2011, but simultaneously a petition was filed before NJT. And you know, and on 7th of April 2016, an order was passed in which the project was declared unviable. And you know, that's why the project became unviable. That's why we demand seeking our investment. There's security deposit to the extent of 25 crore was deposited. You know, one of the clause of this agreement says that if the project become viable without any mistake of the petitioner, then the government has to release that amount. So the dispute started in 2019 based on this. You know, there's one report saying that the project is unviable, and we filed a case of Section 9 before the district court. You know, seeking the deposit, refund of the security deposit. Then after, you know, the district court under Section 9.
which clause you are referring to that the
Yes, sir.
government will have to, if it is clause number?
Your Honor, clause number 15.4, Your Honor.
Huh?
15.4, Your Honor, it's on page number 122. In the event the project become not viable after the DPR, such upfront payment shall be refunded to the company without any interest on it. But if the project is not taken up due to the fault of the company, the state government shall have the absolute right to forfeit the upfront payment.
So you signed an MOU, you made initial investments, but there was delay in environment clearance.
No, Your Honor, we received the environment clearance in 2011. There was a petition filed in NGT. The NGT come to a conclusion, this report should be made with respect to this project. When the Wildlife Institute, Dehradun, made that report, it said that there's a bird called black neck crane, which is harmed if the project is continued. On the basis of that, the project was declared unviable, Your Honor.
For environment reasons.
Yes, Your Honor.
All right, you take down hard, Mr. So-and-so, and counsel for I've already dictated that one, you say it. By filing this petition 5 and 6, paid for an order for appointment of an arbitrator so as to enter into a reference with regard to the disputes and differences arising by and between the parties within the ambit of the MOU dated 28/5/2009. The facts of the case, in a nutshell, are that the petitioners herein had entered into a memorandum of understanding (MOU) with the state government of Arunachal Pradesh, represented by the Chief Secretary (Power), that is the sole respondent herein, for establishment of Namyangchu Hydroelectric Power bracket HEP bracket close stage 1. You will get it in page number 107. The blue mark, you just put it. Whatever is blue mark, just put it to insert. Full stop. After execution of the MOU, after the signing of the MOU, the petitioner had apparently prepared a DPR and had also obtained environment clearance. Whereafter, they had made substantial investments for execution of the work. However, in between, raising issues pertaining to environment raising environment-related issues. A proceeding was instituted before the Honorable National Green Tribunal, which had resulted into a declaration to the effect that the project was not viable. First up, consequently, the project got scrapped. First up, according to the petitioners, in view of clause 15.4 contained in the MOU dated 28/5/2009, according to the petitioners, since the project had to be scrapped SCRA PPED for reasons not relatable to the petitioner, nor on account of any default on their part. Hence, in deference to clause 15.4 of the MOU dated 28/05/2009, they would be entitled to receive compensation from the government of Arunachal Pradesh in the form of refund of the upfront amount. However, the demand raised by the petitioners to that effect had not been acceded to by the respondents. Hence, respondent, full stop. Next paragraph. Mr. So-and-so learned counsel for the petitioner has invited the attention of this court to the arbitration clause in the form of clause 13.1 in the MOU dated 28/5/2009, as well as the legal notice dated 10/7/2020 issued to the sole respondent on behalf of the petitioners demanding arbitration, to submit that despite receipt of the aforesaid notice, the respondent has not taken any action to appoint arbitrator. Full stop. It is also the submission of Mr. So-and-so that that in the petition itself, the petitioners have suggested the names of four former Supreme Court judges to be chosen as the sole arbitrator, so as to enter into a reference with regard to the dispute, and therefore this court may pass an order appointing sole arbitrator. Full stop. Responding to the above, Mr. S. Tapin Lanet, counsel for the sole respondent, has argued that his client would not have any objection to one of the four names, to the name of Justice Madan B. Lakur, bracket former judge of the Supreme Court of India, bracket close, as suggested by the petitioner, to act as an arbitrator in this case. But according to Mr. Tapin, it should be a 3-member arbitral tribunal, and therefore the respondent should be allowed to nominate one arbitrator from one arbitrator for constituting the three-member arbitral tribunal. Full stop. It says,
On a small thing, lordship. In reply to this, our reply, lordship, rejoinder pivotal. They have not, lordship, objecting this three members body arbitration body, lordship. In reply in 145 laws, they have not, lordship, exactly disputed laws.
he's not agreeable to a three-member. That's
No,
what he
in
said.
their reply, they have filed the rejoinder to our reply laws. In our reply laws, we categorically propose 40 members arbitration body laws. In this reply, they have filed rejoinder laws. Reply
Correct, but orally he is objecting.
no, sir.
What is the last line? Mr. Topin has also invited the attention of this court to the rejoinder filed by the petitioners to submit that they have also not opposed the proposal for constitution of a three-member arbitral tribunal. Full stop. The learned counsel for the respondent has, however, not denied that there is an arbitration agreement in the form of clause 13.1 of the MOU dated 29/5/2009, and therefore the disputes and differences arising by the parties is required to be referred to the arbitral tribunal. At the very outset, this court is of the opinion that after hearing the submissions of learned counsel for both the sides, what is apparent is that there is no dispute by and between the parties as regards the existence of an arbitrable dispute by and between the parties, or the existence of an arbitration agreement which would require the matter to be referred to arbitration. The only dispute, if any, in this case is pertaining to the number of members in the arbitral tribunal system. While the petitioner's counsel has submitted that his clients are insisting for an arbitral tribunal constituted by sole arbitrator, the respondents are seeking a three-member arbitral tribunal. There is no indication in the arbitration agreement as to the number of arbitrators that will constitute the tribunal in case there is a dispute arising within the ambit of this MOU dated so and so. The clause 13.1 of the MOU is reproduced herein below for ready reference. You will get it in page number 120. Section 10 of the Arbitration and Conciliation Act 1996 deal with composition of arbitral tribunal. Section 10 is reproduced herein below for ready reference. From a plain reading of the aforesaid provision, it is clear that while the parties are free to determine the number of arbitrators that should constitute the arbitral tribunal, in case of failure to arrive at such determination, the arbitral tribunal will consist of a sole arbitrator. The aforesaid position also finds due reflection in the decision of the Supreme Court rendered in the case of Citibank, NA versus TLC Marketing, PLC, and another reported in 2008 bracket close 1 SCC 481 relied upon by the petitioner's counsel. First up, it is no doubt correct that there is no specific stand of the petitioners in the rejoinder as regards the number of arbitrators to be included in the arbitral tribunal. However, the petitioner's counsel has orally objected to such a prayer. First up, as such, the issue, in the opinion of this court, will come within the domain of sections 10, bracket 1 and bracket 2 of the Act of 1996. If that be so, there can be hardly any doubt about the fact that the arbitral tribunal will have to be constituted by sole arbitrator. Since both parties are agreeable to the name of Honorable Mr. Justice Madan B. Lapoor, former judge of Supreme Court of India, to act as a sole arbitrator, this court, in exercise of powers conferred under section 11, bracket 6 of the Act of 1996, hereby appoints so-and-so Honorable Justice so-and-so to act as the sole arbitrator, registry to issue notification after obtaining the consent of the proposed arbitrator in the matter. With the above observation, this arbitration petition stands disposed of.
Item number 10.
But you are in serious trouble. You are lucky that they are not, maybe they are not conversant or they are not raising this point. This arbitration clause is gone. But absolutely shabbily drafted. Yes. Yes, what is it?
May I, Your Lordship? Your Lordship, I'm representing the petitioner on behalf of leading counsel, O Modi. Lordship, O Modi is, leading counsel O Modi is not available today, as he is out of station.
On the prayer of petitioner's counsel, this matter stands adjourned for 2 weeks. Yes.
May I pray for 3 weeks time?
3 weeks too.
Yes.
Yes.
And, my Lordship, there's a interim order, may it
Interim
continue?
order passed earlier to continue.
Okay.
Yes, number 3, number 13.
Number 11. 11. I think number.
Much obliged.
Yes.
Lordship, I beg to state that the leading counsel is out of the station. That the leading counsel is out of the
On the
station.
prayer of petitioner's counsel, this matter stands adjourned for 3 weeks. Yes.
Obliged.
Same order, 3 weeks.
2 weeks, man.
2 weeks.
2 weeks for adjournment.
Item number 12.
Yes, 2 weeks. Item 12, 2 weeks.
For 2 weeks, man.
Prayer of petitioner's counsel stands adjourned.
Item number 13.
This matter also, the notice was issued to seek instructions, and I was told that, my lord, they will be filing an affidavit. But,
This is also same thing as item 3.
similar, my lord, but different tender under the same department, different tender for different product.
So we'll fix it on 8th only, along with item 3 and 5.
I think, my lord, a different date may be posted because the subject matter is a little different. And I am told, my lord, there is some development in the matter which may require.
Mr. S. Duttal and senior counsel has appeared for the petitioner. None appears for the respondents. You're there? What is your stand?
Respondent number 1 and 2, Your Lordship.
Miss so-and-so appears for respondent numbers 1 and 2 and prays for 2 weeks, 3 weeks further time to obtain instruction and file affidavit. In view of the above, this matter stands adjourned for 3 weeks. So as to enable the learned department counsel to file affidavit.
Lordship may kindly fix a date of after this,
Yes,
maybe on 22nd of April.
On the request of both the sides, this case again on 22/4/2024 as a fixed item.
One second.
Item number 34. Mr. Day. Item 34. What are these cases? Appointment of arbitrator?
My lord.
Please, my lords.
First,
The,
let me see. First,
my
let
lords,
me
the
see what-
application, all the 4 applications are for appointment of arbitrators. My lords, we have also submitted a synopsis today before the Honorable Court.
Where is the synopsis? They have submitted synopsis. Where is it?
My lords, the synopsis pertain to very short, brief note for my lords, which contains the nature of work, the date of invocation of execution of work, as well as the date of appointment of arbitrator. I will firstly take my lords to the arbitration clause.
Yes. Where is the arbitration clause?
My lords, the arbitration clause is at page number 80 of the paper book.
80.
Yes, my lords. Should I read, my lords?
And then where is your demand? Where is the notice?
My lords, the invocation demand is annexure 9, page 121 of the paper book. Point number 4, my lords. It says that by way of this notice, we hereby invoke the arbitration clause, and the Director General of Border Roads is therefore requested to refer the dispute to the arbitration by appointment of an independent and impartial arbitrator within 30 days from the receipt of from the date of the receipt of the letter. My lords, their denial is is annexure 10, that is page 123 of the paper book. Point number 3, my lords. It says that further, due to introduction of the Arbitration and Conciliation Amendment Act 2015, a waiver as per subsection 5 of section 12 of the Act is required to appoint a serving engineer officer of the department as the arbitrator as per the arbitration agreement in the contract. Point number 4, my lords. In this instant case, you have not given the necessary waiver as per subsection 5 of the of section 12 of which it is mandatory, but while the paragraph 6 of your above stated letter dated 23rd Jan 2023, you have requested to appoint an arbitrator. Point number 5, my lords. Hence, in such a scenario, the appointing authority, that is the DGBR, is not in a position to appoint the arbitrator as per the arbitration agreement.
So other cases, everything is similar.
Everything is similar, my lords.
Same contract agreement, same clause, everything is
My
similar.
lords, the contracts are different, the kilometers, the stretch is different, but everything else is similar. Similar contract, similar. This is a typical MES contract with the border road organization, and the invocation date is also the same, and the specific denial of the respondents is also on the same date.
You agree?
Yes, well, since that letter has been responded by the department, saying that for waiver of the reference for the appointment to the serving officer, of course, there is a the restrictions under section 12,
But the arbitration clause does not mention serving officer.
it is mentioned,
If you don't appoint within 30 days, then you lose the right. You should have appointed the serving officer within 30 days.
Therefore, the agreement has to be agreement has to be first given that he has not done. Therefore, in the letter, it is very much clear.
This is the agreement. Clause 70 is the arbitration agreement.
Correct, madam.
So it does not say who will be the.
My lords, it states that it is going to be a serving officer,
Correct.
but my lords, as per
But
the
he was not appointed. After receipt of notice, you could have appointed him.
Madam, there has the agreement has to be given, madam. Our specific the reply was for giving if lordship again may read the reply given by the department, wherein it has been specifically mentioned that agreement has to be given, madam.
So you have made similar reply in all the cases.
Madam.
All the cases.
Madam, what we have specifically said is unless both the parties agree in writing. And I'm reading again 123 page, madam, annexure 10 of arbitration petition, madam. 123, madam.
my lords, even otherwise,
Unless
section
No, you have
12(5).
to wait. You can't do it like this.
Please, my lords, please.
You are on VC. You have to wait for your turn. You can't.
Madam, I'm reading, madam. Just below, madam. Madam, I'm reading para 2, madam. In this connection, it is intimated that the arbitrator in any dispute is appointed as per the arbitration agreement between the parties, that is the department and the contractor. The condition 70 of the so and so, the forming part of the contract agreement state is all disputes between the parties to the contract other than those for which the decisions of the task force commander or other person is by contract expressed to be final and binding shall, after written notice by either party to the contract to the other of them, we refer to the sole arbitrator of a serving engineer, madam, officer having degree in the engineer or equivalent or having passed final or direct final examinations of the subdivisions of the institutions of the surveyor India recognized by the government of India to be appointed by the competent authority the mentions in the tender documents. This is the arbitration clause, madam.
So
And
they are they agreeable to serving engineer? They are not.
And madam, unless madam, our contention is unless both the parties agree, madam, both the parties agree in writing, such reference shall not take place until after completions of or completions of the work or terminations or determination of the contract under condition number so and so. Well, this is the only sole contentions. The waiver has to be given for the appointment of the arbitration. Right or wrong, the arbitration, though there is of course restrictions imposed under section 12. However, that has not been taken into consideration. They agreed And my lord, the contract agreement was entered into. And the section clause 70 has been also, my lord, accepted, my lord. That is the, my lord, the conditions of the department.
And where is the judgment of the Supreme Court where it has been held that if the other side does not appoint an arbitrator within the time stipulated in the notice, their right to appoint an arbitrator is forfeited? Where is that judgment?
Well, I'm sorry, I
Manoj,
tried. I'm sorry, my lord, I tried to find out the judgment, my lord, but I could not.
All right, then you get the judgment. You get the judgment also.
we will,
We'll
Manoj, we will provide
we'll
that.
assemble at 2 again. At 2 again, we'll assemble, get the judgment. So otherwise, everything is same in all
My lord,
other,
same.
everything is
Only
same.
contract agreements, package of work are different, my lord.
And
Parties are
supposing
same.
we appoint an arbitrator, do you have an agreement on a name?
My lord, the agreement is, we have our own, my lord, the list of the, my lord, this is the list, my lord.
No, it will not be from your department. That is over.
Yes, ma'am.
That will not be for
My
department.
lord, this is not from
No.
our department, ma'am.
Let us see.
Manoj, we are okay with any name from the panel that is given by the Honorable Guwahati High Court.
Same list, ma'am.
So tell me, from the panel, you agree
Manoj,
on one name?
Honorable Justice A.K. Goyal, Honorable Judge of the Supreme Court.
Okay,
Since contract agreement is within the jurisdiction of this honorable court, so therefore, my lord, my lord, prayed it, in the event of my lord, appointments of the sole arbitrators, my lord, may be appointed either serial number 4, 3 or 4, my lord, of our own high court, my lord.
No, all of them stay in Delhi. They are all residents of Delhi. So whoever you appoint, the arbitration will take place in Delhi. These are all central agencies. What is the difficulty?
However, my lord, all the correspondence, everything has been done from this project unit only, my lord.
Correct. Sitting, the arbitrator will decide.
My lord.
Doesn't make any difference.
But my lord, all the my lord, paperwork, everything, my lord, the officer concerns who has the project.
Are you agreeable to number 4? Justice Deepak Gupta, both sides
Manoj,
agreeable?
we are agreeable. We are agreeable to any name from
You are agreeable? Justice Deepak Gupta.
My lord,
he is a former Supreme Court judge. He was the Chief Justice of Tripura. And if you are agreeable, then say that we'll pass an order at 2. But get the judgment which says there is a waiver of. All right.
Well.
Okay, then we'll reassemble it. Then we'll seek the consent of Justice Gupta. If he is willing, then the order will be passed at least.
Well, in the meantime, I'll take a call from the consent department, my lord.
All right.
Diplomacy.
Obliged.
List.
By another 2 weeks, so as to enable them to examine the relevant notification fixing pecuniary jurisdiction of the civil courts. Oh, list accordingly. Yes. So you've got the judgment? You've got the judgment?
Mine. Altogether 84 pages. So therefore,
all right. Just give us
paragraph 85, 84, 91, 92. Very not exactly the waiver, how it
yes. Have you got the judgment I'm asking for?
Yes, madam.
We have the judgment.
Dr. Sujgar, which paragraph?
Page number 5, para number 2 on page number 5. So far as under section subsection 6 are concerned, such as the one before us, no time limit has been prescribed under the Act, whereas a period of 30 days has been prescribed under Section 11.4 and subsection 11.5 of the Act. In our view, therefore, so far as Section 11.6 is concerned, if one party fails,
You are reading from which page, madam? Which decision?
Miloj, this is data switchgear.
Dr. Surya, yes. What has been held here?
Miloj, it has been held that even if the respondents do not appoint an arbitrator within 30 days, their right is not forfeited. However, their right is forfeited once the application under Section 11 has been filed by the petitioner.
And what has been held in this case? Parmar construction?
Similar, my lords. Both of them are similar. This is
Page
para
number?
42. Para
Page
42, my
number?
lords. Para
Para?
42 of this. 42, my lords.
Yes. And what are you relying upon?
That kind of Lombardy name of the party Lombardy Engineering Limited purchase Uttarakhand Nigam Limited in this case, only the equipment in respect of the arbitrator to be from the neutral and the other independent equipment of the arbitration. Still, our time and substance is the equipment. We don't have any objection to the equipment. Is the very thing we decided in the arbitration. But our only failure is the to be made from our own list of their own.
Yes, obviously. We'll make from the list of panel prepared by the High Court.
Panel of our own High Court, as second serial number 4, 3 or 4.
All right. All right. You take down. Party's name, put the party's name, counsel's name. Give a slip. First up. You take. This application under Section 11 bracket 6 of the Arbitration and Conciliation Act 1996 bracket hereinafter referred to as the Act of 1996 bracket close has been filed by the contractor with a prayer to appoint the sole arbitrator to enter into a reference with regard to the disputes in question. First up, the facts and circumstances of the case, leading to filing of this petition, briefly stated, are that the respondent, which respondent had issued the NIT? The respondent BRO, Border Roads Organization,
Border Road Organization,
had issued a notice inviting tender, NIT, dated 16/12/2019 for execution of a contractual work at the estimated cost of 2856.76 lakhs, briefly stated, as apparent from the materials on record. Estimated at 2856.76 lakhs, pursuant whereto the petitioner had submitted its bid and was eventually awarded the contract. Full stop. A contract agreement was accordingly executed by and between the parties on 15/2/2020. Full stop. However, while executing the contractual work, the petitioner claims to have incurred certain additional expenditure due to escalation of price of raw materials on account of outbreak of COVID-19 pandemic. Full stop. According to the petitioners, the excess amount incurred by it is to the tune of 9 crores. Full stop. Therefore, the petitioner had raised this claim with the respondent by submitting letter dated 11/10/2021 and 8/11/2021. Full stop. However, the claim of the petitioner was rejected by the respondent by letter dated 4/2/2022. Hence, the petitioner had invoked the arbitration clause in the contract agreement in the form of clause 70 and by letter dated 23/01/2022 had demanded that an arbitrator be appointed so as to enter into a reference with regard to the dispute. Full stop. However, no such arbitrator was appointed by the respondent. On the contrary, by reply dated 9/2/2023, the respondent has inter alia stated that unless both the parties agree in writing, reference will not take place. Both the parties agree in writing about what?
Giving waiver to section 12, subsection 5, my lords.
To appointment of a serving engineer of the department and to the waiver under subsection 5 of section 12, appointment of arbitrator will not be possible. Full stop. Situated thus, the instant application has been filed by invoking the jurisdiction of this court under section 11(6) of the Act of 1996. Full stop. During the course of argument, Miss So-and-so, your name please?
Lakshata Sahani.
So-and-so, learned counsel addressing this court through RVC has contended that since there is an arbitrable dispute by and between the parties, and in view of clause 70 in the contract agreement, it was incumbent upon the respondent to appoint an arbitrator. But, full stop. However, no such action was taken. Appoint an arbitrator pursuant to the request made by the petitioner by letter dated 23/1/2022. However, instead of doing so, the respondent has set terms and conditions to be complied with by the petitioner by letter dated 9/2/2023, which were not at all tenable in the IF law. contending that the time, not at all. By referring to the decision of the Supreme Court rendered in the case of Tata Switchgear Limited versus Tata Finance Limited and another, reported in, you have to find out citations, give him the citations, find out and give him the citations, as well as in the case of Union of India versus Parmar Construction Company. Ms. So-and-so has argued that the respondent, having failed to appoint an arbitrator within 30 days of receipt of the request, or at least prior to filing of this petition, has waived its right, if any, under the contract agreement to appoint an arbitrator. As such, an order be passed by this court appointing an arbitrator from the panel prepared by the Guwahati High Court and notified by notification number 99 dated 4/8/2023. Stop. Right. Mr. M. Kato, learned counsel appearing for the respondent, has neither denied the existence of arbitration clause nor as he disputed the claim of the petitioner that there are some dispute and differences existing by and between the parties which requires resolution by referring the same to a sole member, by referring the same to an arbitral tribunal constituted by a sole arbitrator. Mr. Kato merely submits that his client could have no objection if an arbitrator is appointed from the panel notified by the registry of this court bearing number 99 dated 4/8/2023. Stop. It appears that the arbitration agreement is contained in clause 70 of the agreement dated 70 of the agreement dated contract agreement dated 15/2/2020 signed by and between the parties. Clause 70 is reproduced herein below. You'll get it in page 80. Page 80, double tick to double tick, this clause. First up. From the above, it is clear that there is a binding arbitration agreement by and between the parties. As such, any dispute arising within the ambit of the contract agreement would have to be referred to adjudication by the arbitral tribunal. First up. In view of the consensus at the bar that there are some disputes and differences by and between the parties which calls for resolution by referring the same to the arbitral tribunal, and also the agreement between the parties to appoint an arbitrator from the panel notified by the High Court on 4/8/2023, with the consent of both the sides. Honorable Mr. Justice Deepak Gupta, former judge of the Supreme Court of India, is hereby appointed to act as the sole arbitrator so as to enter into a reference in respect of the dispute involving in this case. Full stop. Registry to obtain the consent of the learned sole arbitrator and thereafter transmit the records for further action in the matter. With the above observation, this petition stands disposed of. Right? So same order, the only thing like this, the dates.
Plus the dates might change. The notice
So,
inviting.
please ask your junior to render assistance.
I
to
will
my
do that. I will do
secretary.
that.
All these are here, the same arbitration clause. Just type out this and then corresponding changes. So here are the synopsis.
One thing, the merits of the case will be immediately before the solar. Here.
You said that the arbitral award will be passed by the arbitrator. That must have have a limit to what you are asking, huh?
This is affidavit filed by the respondent. There is no clause for escalation of the file. Escalation.
That is what the arbitrator is supposed to decide. How many petitions are there?
4, my lord.
So these are the 4 synopsis. Corresponding. And all are regarding price escalation. All regarding this
Similar issue.
COVID-19 related escalation. So disposed of all 4 proceedings as well as the notings of the registry to submit that although the respondent numbers 1 and 2 have entered appearance, yet no counsel remains present when the matter is called up. He further submits that although there is a local counsel, namely Mr. D. Loy, who is appearing in this case, he also remains absent, although the name of the counsel is shown in the cause list. Full stop. In a contempt case, if the respondents remain absent despite receipt of notice, it will be a fit case for this court to proceed against them by directing personal appearance in the matter. However, considering the peculiar facts and circumstances of the case and for ends of justice, this court is inclined to give one more opportunity to the respondents to appear in the matter. The registry to therefore notify the counsel for the respondent numbers 1 and 2, bracket, including the local counsel, to remain present either physically or through VC on the next date fixed. It is made clear that if the respondents fail to appear on the next date, this court will have no option but to direct their personal appearance. The registry will list this case again on 8th of April 2024 as a fixed item. Item number 15.
May I please, Your Lordship?
Yes.
Notice issued for the service, Your Lordship, to the respondent number 5, but still we have not received the service report. Maybe fixed after 3 weeks, Your Lordship. And interim order is there in this case.
Await service report on respondent number 5 for 4 more weeks. Mr. I. Riram and GA AP is present on behalf of respondent 1 to 4. Interim order, if any, passed earlier to continue till the next day.
Oh, bless you, Lordship.
Item number 16.
My lord, pleadings are completely fixed for admission.
It is submitted at the bar that this matter is ready as regards pleadings and service. As such, registry to list this case for admission. When?
After 2 weeks,
After 2 weeks. All right. All right. Item number
there was an interim order.
Interim order, if any, to continue until further orders.
Obliged.
Yes.
Lordship, may I allow to some more time to file affidavit pertaining to justice service.
The petitioner's counsel, Mr.
N. Chatum.
N. Chakum.
Yes.
Praise for and is granted 10 days further time to file affidavit pertaining to the justice service of notice upon respondent number.
No, I'm for petitioner. Or respondent number 4.
Respondent number 4. List accordingly.
Obligement.
Item number 18.
Your Lordship, this is an application for modification of the order and to fix a specific time frame.
Which
So
order?
This order is in Annexes 1, page number 7. It's a may I read out.
You are for the respondent.
No, I'm for the applicant, PM petitioner.
You are for the petitioner.
Yes. Because here, though direction was issued to the respondent authority to take actions, but no time frame was given. Though I had filed a complaint in 2020, now it's almost 4 years.
This IA cannot be entertained. It's a disposed of writ petition.
This is a disposal, because I only
No, it
a
cannot be.
time frame can be fixed, Your Honor.
No, then you have to ask for review of this order. Or you file a contempt.
Because contempt I cannot file because no time specific time is given here. Because until and
So,
unless
so in a disposed of writ petition, this order cannot be passed. There are many decisions, Supreme Court, High Court.
but
This
the
case
thing is
is
that
disposed of.
here I
You
am
want the order passed in disposed of case to be changed
then I will
or
have
added. That cannot be done. You have to file a review petition.
okay, I will do that. I will file a review petition
All right,
because in this
Mr.
case I'm just handicapped because
No,
I
I
cannot even
understand, but you have to
file
take
contempt also.
You have to take the right recourse. So you either ask for review or appeal.
Yes, I
or
will ask for
contempt.
review.
But you are making IA in a disposal of writ petition.
So I will go for the
All right,
review.
Mr. D.K. Deori, Learned Counsel for the applicant, prays for leave of this court to withdraw this IA with liberty to prefer a review application against the order dated, no, against the in respect of the order dated
Order dated 27/2023.
27/2023 passed by the Learned Single Judge in WPC number 316 of 2021. Mr.
V. Jamo.
So and so and Mr. S. Tapin, Learned Senior Government Advocate AP are present on behalf. Put the name of Mr. Tapin first. You have 1, 2? 1, 2, 3 and you have 4?
4, 5 laws.
4 and 5. So put them serially. Are present and do not have any objection. In view of the above, the IA stands disposed of on withdrawal with liberty as paid. Yes. Item number 19 and 20.
May I please, Your Lordship, this is eviction matter, Your Lordship. And 19, Your Lordship, there was an order from this court also. In that we post this court, I was being aggrieved by the order passed by the state official, Lordship. For that, considering my cases, Lordship, on 6/4/2023.
Numbers 2 to 4.
File another in the is bringing JCP and all, and being aggrieved, and we approach this court also. And in that, we have a 6 and 7. There is a private party. We have services also completed, and in that case also the government, they have filed an affidavit in possession, and private parties also filed. But in that cases, 7 is still remains yourself. They have not filed any affidavit till now, Lordship.
So who's appeal? You have for 1 to 4.
Lordship, important, we have already filed our affidavit, Lordship.
You want to file any rejoinder?
A rejoinder, yes, Lordship, we want to file. But in 20 cases, the service is completed. Against the
20 will pass on.
yeah.
Now let's.
And 19 also, we have an interim order, Lordship.
You write like this, Mr. R. Riram, Learned Additional Senior Government Advocate AP, appearing for respond numbers 1 to 4, submits that counter affidavit on behalf of the department has already been filed. Stop, Miss
Kanada.
Okay, so and so Learned Counsel for the petitioner prays for 3 weeks time to file rejoinder.
In case of 183, Your Lordship, interim order is there.
Let this matter be listed again with item 20 after 3 weeks. Interim order passed earlier to continue.
Yes.
Then like this. I, Riram, Learned Additional Senior Government advocate appears for the respondent numbers 1 to 5. Record reveals that service is complete on respondent number 6 and 7 as well. In view of the above, registry to list this case along with item 19. You put the case number, in item 19, put the case number. After 3 weeks, interim order passed. Interim order, if any. is there any
183, yes.
Interim order, if any, shall continue.
And in case of lordship, in 183, we want to file rejoinders, lordship, 183, 19 ones.
Yes, I've already passed that.
Yes, yes. Obliged.
Item number 21 or 22.
I'm for the petition, my lord. I'm supposed to file my rejoinder in item number 21, my lord. IA, which has been filed by the private respondent, my lord. So I need time, my lord, to file rejoinder.
What is this IA for?
IA is for vacating of interim order, my lord. Interim order, my lord. For vacation of interim order.
Vacation of interim order.
Yes, my lord.
Who has filed the IA?
Private respondent, my lord. Since they're absent, my lord.
Your lordship, I'm for government.
Private respondent is not there.
Private respondent is not here.
Acha, you write then in the IA, you pass the order. The learned counsel for the applicant in IA. IAC 219/2023 is not present when the matter is called up before this court. Mr.
El Kurdu.
El Kurdu, learned counsel for the writ petitioner stroke OP, raised for some more time to file affidavit. Miss
P. Sangeeta.
P. Sangeeta, learned GAP is also present. Since the applicant's counsel is absent, this matter stands adjourned for 3 weeks so as to allow the counsel for the writ petitioner OP to file rejoinder. Affidavit or rejoinder?
Rejoinder, my lord.
Then earlier I have written affidavit, you write rejoinder.
Item number 22, my lord. Interim may continue, my lord.
Item 22.
Yes, my lord.
Heard learned counsel for the parties present. List this matter again after 3 weeks. Interim order, if any, to continue.
All right.
Item number 23.
Your Lordship, in this case, I'm challenging the ad hoc appointment issued to the respondent number 4 in contravention with the guideline and a notification issued by the
Orders, what order?
because the instruction, he was directed to appear before the court on the last date. Because notice was already served, copy was already served to the standing counsels, to the private respondent. Despite receipt of that notice, he had not appeared. So for his appearance, if he has any objections, I think he is not appearing.
Yes, then we'll dream service is complete.
Service is complete.
For admission, disposal and admission stage.
Disposal. Yes.
Huh?
Okay.
But
I think
Mr.
it can be
DK
disposed of today, that'll be gone.
Today not possible. Heard Mr. D.K. Deuri, learned counsel appearing for the petitioner, also heard Ms. P. Sangeeta, learned GAP, and Mr. L. Parme, learned SC Power Department.
In the, sorry, my lord, in